Imagine a high-stakes corporate lawsuit. I mean, we are talking about hundreds of millions of dollars on the line here.
Oh, absolutely. The kind of intellectual property theft that could just completely tank a Fortune 500 company.
Right, and you've got news vans idling outside the courthouse. So the digital forensics expert takes the stand. They have the data.
They have that undeniable cryptographic proof.
Exactly, proof that the CEO committed fraud. And the courtroom is just dead silent. But then the opposing counsel stands up, and they don't attack the data.
No, they don't even look at the hard drive.
Right. Instead, they attack the expert's software license. They pull up some casual conversation the expert had like 3 years ago in a hotel lobby at a cybersecurity conference.
And just like that, the trap is sprung.
Yeah, within 5 minutes, the expert is completely disqualified. The judge strikes their testimony from the record, the evidence is thrown out, and the entire case just collapses.
It's brutal.
It really is. So what happens when the person hired to uncover the digital truth becomes the exact reason the truth is buried? Welcome to the deep dive.
It's a scenario we really need to unpack today.
For sure. And hey, if you want to survive these legal minefields and build a bulletproof career in IT, hit subscribe right now. Today, we are giving you the survival guide. Also, be sure to check the description below for access to additional resources we've curated just for you.
Because that opening scenario, it is the ultimate nightmare for any investigator. And unfortunately, it happens, entirely too often.
Wow, really? So it's not just a TV drama thing?
Not at all. The data is rarely the weak link. The human being interpreting the data, that's the vulnerability. I mean, if you don't understand the professional battlefield you're walking into, your technical skills are essentially useless.
And that is exactly what we are tackling today. Whether you are a business student at the Dr. Sam Pack College of Business, studying MIS, IT, or you're just fascinated by how technology and the law collide, you are in the right place.
It's such an important intersection.
It really is. So last week, we unpacked the massive logistical world of Chapter 14, e-discovery. We looked at how mountains of digital evidence are managed.
Right, the filtering, the production, all the nuts and bolts.
Exactly. But today, we are crossing the finish line. We are summarizing and interpreting the insights from Chapter 15, which is ethics and professional responsibilities.
Based on the 2025 edition of Guide to Computer Forensics and Investigations.
Yep. And this is the 15th and final chapter in this specific series we've been doing. We are looking at the human element and how to protect yourself legally when the crosshairs are on you.
And that transition from the raw data to the human element is just so critical.
It's a big shift in mindset, right?
Oh, massive. Our mission for this deep dive is to help you understand a fundamental, really unshakable truth. Your technical brilliance means absolutely nothing if your credibility is compromised.
As you could be like the greatest reverse engineer on the planet, but...
But if a lawyer can prove you have a bias, you are done. Your career is essentially over in that courtroom. So today is all about giving future business and tech leaders practical, actionable takeaways to armor themselves.
Okay, so let's start with the foundation of that armor. When people talk about doing the right thing in the corporate world, they throw the words ethics and rules around like they mean the exact same thing.
Right, they use them interchangeably, which is a mistake.
Yeah, because in the legal and forensics landscape, they function completely differently. I look at it almost like a network architecture.
Okay, I like where this is going.
So your rules of conduct, those are the hard-coded firewall rules. They are external. They are applied to you by the licensing bodies, the courts, or the state. You obey them, or your connection gets dropped.
That is a highly accurate way to frame it. The rules of conduct are imposed upon you from the outside.
Right.
So if you violate a rule of conduct, say by practicing without a required state private investigator license, there's a defined external penalty, a fine, loss of license, something tangible.
But ethics, that's different. That's your internal operating system, right?
Exactly. Ethics are the internalized rules you use to measure your personal performance. They dictate what you do when the firewall isn't looking.
I love that. When the firewall isn't looking.
It's your own moral standard, cultivated by your upbringing, your education, your philosophy.
I've always thought of it like traffic laws versus, valuing human life.
Oh, that's a good analogy.
Like you might not run a red light because, there's a camera and you'll get a $300 ticket. That is external compliance. That is the rule.
Right, the consequence is external.
But you also don't run the red light because you intrinsically understand that T-boning a minivan could kill someone.
Right.
And you value human life. That is ethics.
Yes, and that distinction becomes vital the moment you step into a professional consulting role.
How so?
Well, in the world of digital forensics, one of the most effective mechanisms for protecting yourself is ensuring your internal ethics and the external rules of conduct align seamlessly.
So there's no gap between them.
Exactly. You want absolutely nothing to hide. Because the moment you take the stand, the opposing counsel is going to look for any daylight between what you are legally required to do and what you personally believe is right.
And taking the stand is where the pressure cooker really turns on. Looking at the sources, they point out that an IT professional or forensics examiner can play two very distinct roles in a courtroom.
Yes, you can be a fact witness or an expert witness.
And it feels like stepping over a tripwire. How do you actually know which one you are?
It all comes down to interpretation. A fact witness is constrained strictly to the observable facts found during evidence recovery.
So just the raw data.
Right. If you are called as a fact witness, you are essentially a human readout of a log file. You sit in the chair and say, well, you say something like, I imaged this specific hard drive on Tuesday. I navigated to the documents folder. I found a file named financials.xlsx, and the creation date was October 4th.
And that's it. You don't say anything else.
That is the absolute limit of your testimony, just the facts. You do not explain what it means.
So you are literally just the delivery mechanism for the data.
Precisely. But an expert witness does something fundamentally different. They render an opinion. And they are allowed to do this because the court recognizes their specialized education, training, and experience. So an expert witness doesn't just say they found the Excel file.
What do they say?
They look at the jury and say, based on my 10 years of experience analyzing corporate fraud, the metadata associated with this file, specifically the mismatch between the creation date and the modification date, suggests this file was intentionally altered.
Oh, wow.
Yeah, altered by the user using a specific anti-forensics wiping tool to hide stolen assets.
So the fact witness just says it is raining. The expert witness says it is raining because of a low-pressure system, and based on the barometric pressure, we are going to have a flood.
That is a perfect way to put it, and the moment you provide that why and that how, you cross the threshold. Exactly. Let's look at a scenario from our case studies involving an examiner named Paolo.
Okay, let's hear about Paolo.
So Paolo is brought in to testify about malware found on a corporate server. He starts out just listing the file directories where the malicious code was hiding. Fact witness stuff.
Right. Just reading the logs.
But then the attorney asks him how the malware propagates through a network. Paolo starts explaining the mechanism, drawing on his background in network security.
Which seems innocent enough.
It does. But then suddenly he states that he believes the malware was deployed deliberately by an insider rather than an external hacker.
Bam. He just rendered an opinion based on his specialized knowledge. He crossed the tripwire.
He did. And the moment Paolo renders that opinion, he instantly becomes an expert witness in the eyes of the court. He is no longer just reciting facts.
He's interpreting it all for them.
Yes. He's translating a complex digital ecosystem for a jury that probably doesn't understand hexadecimal code. And that places an incredibly heavy legal and ethical burden squarely on his shoulders.
Because now, his background, his education, his certifications, and his character, they are all officially part of the evidence.
They are. And this brings us to one of the most critical legal frameworks in the U.S. legal system. Honestly, something every single business or tech student needs to understand if they ever plan on doing consulting work.
The Daubert standard, right?
Yes, the Daubert standard. It stems from a landmark 1993 Supreme Court case, Daubert v. Merrill Dow Pharmaceuticals, Inc.
Okay, so what was it like before 1993?
Well, before Daubert, courts generally used something called the Frye standard, which basically just asked if a scientific technique was, generally accepted by the scientific community. It was a pretty loose metric.
Let me make sure I'm getting this. So, under Frye, if enough of your IT buddies agreed your software was cool, the judge would let it in.
Essentially, yes, it was a lower bar. But Daubert changed everything. The Supreme Court established that the judge must act as a gatekeeper.
A gatekeeper for what?
To ensure that expert testimony is not only relevant, but truly reliable. It cemented the ethical responsibility of an expert to present a complete, scientifically valid, and entirely unbiased picture of the research.
Unbiased being the key word there.
Exactly. Under Daubert, your role is not to be a hired gun. Your role is to act as an impartial educator for the judge and the jury.
Okay, wait. I'm stuck on something here. This feels like a massive contradiction in the real world.
How so?
Well, if I have my own forensics consulting firm and some high-powered defense attorney writes my company a check for $20,000 to be their expert witness, shouldn't my job be to help them win?
You would think so, right?
Yeah. They are the client. If I'm an impartial educator, how does that make sense when I am literally on their payroll?
I am so glad you asked that because it is the single most dangerous misconception you can have as a professional. It has ended countless careers.
Seriously.
Yes, the attorney is paying your fee, but they are paying for your objective expertise and your time, not your loyalty.
Wow.
They are paying for your ability to apply the scientific method to their digital evidence. The American Bar Association, the ABA, states very clearly in its model rules that expert witnesses, unlike attorneys, do not owe a duty of loyalty to their clients.
That's fascinating. So the lawyer has a duty to advocate for the client, but the tech expert has a duty to the data.
Exactly right. Your duty is to the truth and ultimately to the court. If you conduct your forensic analysis and your unbiased findings completely destroy the attorney's defense strategy, so be it.
You just have to tell them the bad news.
You do. If you try to advocate for the defense by cherry-picking the data or distorting the research to fit the narrative they want, you violate the Daubert standard. You violate your professional ethics and you commit career suicide.
That is a wild paradigm shift for someone just coming out of business school.
Yeah.
Because, you are taught that the client is king and customer service is everything.
Right. The customer is always right, but not here.
Yeah, in this specific niche, the truth is king, even if it gets your client sent to prison.
It is a heavy crown to wear. And
Yeah.
because you are an independent truth teller rather than a team player, it makes you a massive, glaring target for the opposing legal team.
Oh, I bet.
Opposing counsel's job is to win for their client, and one of the most efficient ways to do that is to eliminate the other side's expert witness from the equation before the trial even really begins.
Which brings us to the psychological warfare of the legal system. Because you've got that expert witness hat on, you become a target. And the opposing lawyers have developed an entire playbook to disqualify you before you even see a single bite of evidence.
They absolutely have.
And looking at the sources, the first page of that playbook is something called opinion shopping. What is that?
Opinion shopping is a highly manipulative yet very common tactic. It occurs when an attorney contacts multiple experts, sometimes dozens of them.
Dozens, just fishing around.
Exactly. They present a vague or hypothetical version of their case. They aren't actually looking to hire someone right away. They are looking for an expert who will instinctively give them a favorable opinion based on incomplete facts.
So they are basically interviewing experts to find the one whose initial off-the-cuff reaction best fits the narrative they want to present to the jury.
That's it, exactly.
To use a networking analogy, it's like a hacker executing a SQL injection attack.
Oh, I like that.
Right. The lawyer is probing the expert's internal database with very specific crafted queries, trying to find a vulnerability like a favorable opinion before they ever establish a secure, authenticated connection or sign a contract.
That is a brilliant way to conceptualize it. The psychology behind it is entirely about leverage. The attorney wants to lock you into a viewpoint before you have the full picture.
Let's talk about the case study of Hildy.
Yes, Hildy is a great example. She is a highly successful, sought-after expert witness specializing in computer forensics and corporate fraud.
Okay.
So an attorney calls her up, gives her a very fast, slick pitch about a client who is being wrongly accused of hiding offshore money, and they immediately ask for her professional opinion on the likelihood of the server logs being spoofed.
Ah, so the lawyer's dangling the bait. Hey, you're the expert. What do you think happened here?
Exactly. But Hildy is experienced. She doesn't take the bait. She absolutely refuses to give any opinion on the phone. Instead, she demands that the attorney send her the actual case files, the server logs, and the pleadings so she can make a proper, scientifically sound evaluation.
And let me guess, the attorney just says, never mind, thanks for your time, and hangs up.
They do, because Hildy successfully shut down the SQL injection, to use your analogy. She patched the vulnerability by refusing to render an uneducated opinion.
So holding the line is your best defense.
The most effective defense against opinion shopping is exactly what Hildy did. You refuse to give an opinion until the attorney provides enough material to make a data-backed, Daubert-compliant evaluation.
But the traps are layered, right? Because even if you don't give an opinion, there's the risk of disqualification.
Yes, that's another big one.
This is the formal legal process where a judge rules that an expert is excluded from testifying because they violated court rules, laws, or ethical boundaries. How does an attorney trick an expert into getting disqualified?
The most common and frankly devious method involves conflicts of interest.
How does that work?
Well, let's say a prosecuting attorney knows you are the best network forensics expert in the state. And they know the defense is probably going to want to hire you.
Okay, they want to take you off the board.
Precisely. So the prosecutor might intentionally call you under the guise of an initial consultation and purposefully describe a few highly specific, confidential details of the case to you.
Wait, they tell you the secret stuff on purpose. Why?
Because once you have heard confidential case details from the prosecution, you are legally tainted.
Oh, wow.
Yeah, if the defense attorney calls you the next day to hire you, you have to decline. You are conflicted out because you already hold confidential knowledge from the opposing side.
That is incredibly Machiavellian. It's a predatory ploy just to clear the chessboard of the best experts.
It is, so the other side can't use them.
So, if I am an IT consultant, the moment the phone rings and a lawyer starts talking, I have to throw up a firewall. I can't just dive into the juicy details of the cybercrime.
Ugh. You absolutely must interrupt them. You have to ask exactly who the plaintiff and the defendant are before they share a single detail.
To run a conflict check.
Yes.
Yeah.
You run a conflict check against your past and current clients, and only then do you allow them to proceed, and even then, only with hypotheticals.
Okay, so let's say you navigate the opinion shopping, you dodge the conflict of interest trap, and you actually get hired. Now you face what seems like the scariest database in the legal world.
Deposition banks.
Yes, deposition banks. What are these and how are they weaponized against experts?
A deposition bank is essentially a massive searchable database where attorneys pool and store the past testimonies, reports, and transcripts of expert witnesses.
So it's pure opposition research.
Exactly. When an attorney finds out you are testifying against them, they will run your name through these banks. They will pull transcripts from cases you worked on 3, 5, even 10 years ago.
Looking for what?
They are meticulously searching for any statement you made that contradicts what you are saying today.
That is terrifying. It's like having every single Reddit comment or forum post you've ever written brought up in a job interview a decade later.
It really is.
Let's talk about Chloe. She is a forensics examiner who is facing an opposing counsel armed with a deposition bank.
Okay, let's look at her scenario.
Right, so if Chloe testified in, say, 2020, the data recovery method A is highly unreliable and shouldn't be trusted. But in her current case today, she used data recovery method A to find the smoking gun. She is completely trapped, right?
She is in an incredibly precarious position, yes. The opposing counsel will hand her the 2020 transcript, read her own words back to her, and just ask the judge how they can possibly trust an expert who contradicts herself.
Ouch.
But it is not an inescapable trap if Chloe understands the mechanism of her own field.
So how does she survive that cross-examination without looking like a liar?
By relying on the evolution of technology and explaining the why.
Okay, makes sense.
If there's a change in Chloe's stance on a technical issue, she must logically and confidently explain the contextual shift. She needs to articulate that in 2020, Method A was flawed because of a specific algorithmic limitation.
But then something changed.
Right. Maybe in 2024, a major software update patched that limitation, fundamentally changing the reliability of the tool. Or she can explain that the specific hardware architecture of the 2020 case made the method unreliable back then.
Whereas the current case is different.
Yes, the current case involves a completely different file system where the method is actually the gold standard.
So she isn't contradicting herself. She is demonstrating that her expertise updates alongside the technology.
Exactly. But if she hasn't prepared for that, if she can't instantly and clearly explain the evolution of her methodology, her credibility shatters right there on the stand.
It really is a form of psychological warfare. You are not just defending your data, you are defending the ghost of everything you've ever said in a professional capacity.
You really are.
And this warfare doesn't just happen on paper with transcripts. It happens face-to-face, in real time, during depositions.
Depositions are often the crucible where an expert's resolve is truly tested. And to survive them, you first have to understand the ethical responsibilities that the attorney who hired you, your retaining attorney, owes to you.
Because it is a symbiotic relationship, it's not just you serving them. What do they actually owe you, ethically?
They owe you a fair, comprehensive statement of the case. They owe you adequate time to review the evidence.
So no weekend rushes.
Exactly. You cannot be handed a 2-terabyte hard drive on a Friday and be expected to testify on a Monday.
That makes sense.
And they owe you a reasonable opportunity to examine the data, conduct your testing, and prepare your report without interference.
What happens if they do interfere?
If an attorney tries to rush you or artificially limits the scope of your investigation so you don't accidentally find evidence that hurts their case, they are failing their ethical duty. And honestly, they are putting your career in legal jeopardy.
Okay, so your retaining attorney has to play fair. But what about the opposing counsel? I mean, I know the legal system is adversarial, but surely they can't just bully an IT professional in a deposition room, right?
You would be surprised. While the vast majority of attorneys are highly professional, you have to remember the inherent conflict in the room.
Right.
The attorney's absolute goal is advocacy. They are there to win for their client. Your goal, as the scientist or technician, is objective truth. That friction inevitably sparks heat.
And sometimes they play dirty.
Sometimes, opposing counsel will resort to incredibly inappropriate tactics to rattle you.
Like the financial probing mentioned in the sources. I mean, if I'm sitting in a deposition ready to talk about packet sniffing and network logs, and the opposing lawyer suddenly asks me how much money I have in my 401k or what my monthly mortgage payment is, how am I supposed to react to that?
That is a classic aggressive intimidation tactic designed to make you feel vulnerable and defensive. Let's look at the scenario of Jamaka.
Okay, what happened to Jamaka?
She is a highly qualified expert hired for a cyberstalking case. During her deposition, the opposing counsel starts grilling her about her personal debt and her husband's income.
That feels completely irrelevant. Is there any legal basis for them to ask that?
The only financial questions that are appropriate are those specifically related to your compensation for the current case.
Oh, like, what's your hourly rate today?
Exactly. They are allowed to ask, are you being paid a flat fee or an hourly rate to testify today? Because they want to establish if your testimony is being bought. But asking about your mortgage is crossing a massive line.
So what does Jamaka do? Does she just refuse to answer? Does she walk out of the room?
She doesn't walk out, but she doesn't answer either. This is why having your retaining attorney present, or at least available by phone, is mandatory.
They need to protect her.
Yes. Jamaka should look to her retaining attorney, who should immediately state a forceful objection for the record, citing that the question is irrelevant and designed to harass the witness.
And then what?
The retaining attorney will then instruct Jamaka not to answer. You have to remember, you are an expert there to discuss data, not a punching bag for a lawyer having a bad day.
That's a great point. But the intimidation isn't always verbal, is it?
No, it's not.
One of the most fascinating things in the source material is the concept of environmental manipulation during depositions. It sounds like something out of a spy movie, but it happens in corporate law firms. Let's talk about the visceral example of Galen.
Galen's situation is a perfect study in physiological stress. He arrives at the opposing counsel's massive, high-end law office for a deposition.
And what happens?
He is placed in a small conference room. The air conditioning is somehow broken, so the room is sweltering. The sun is blazing right through the open window shades directly into his eyes, and there is not a single bottle of water on the table.
Oh, man. As someone who gets cranky when I just miss my morning coffee, I can't imagine trying to parse complex forensic data while sweating through my suit and staring into the sun.
Is that just, like, a terrible receptionist, or is it a deliberate tactic? In a high-stakes corporate legal environment, nothing is accidental. Law firm staff prepare conference rooms with microscopic attention to detail.
So they knew what they were doing.
While it could be an oversight, you must operate under the assumption that it is an intentional psychological tactic. Heat and dehydration spike cortisol levels. They cause cognitive fatigue.
They want him to break.
The opposing counsel wants Galen physically uncomfortable so he will become irritable, lose his train of thought, and rush his answers just to escape the room.
So how do you handle that? Do you just grit your teeth and suffer through it to prove you are this unshakable professional?
Absolutely not. Suffering in silence plays right into their hands. Galen must advocate for his own physiological needs, and he must do it on the official legal record.
So not just complaining to the lawyer off the record.
Right. He shouldn't just complain. He needs to make a statement for the court reporter who is typing down every word.
What does he actually say?
He stops the deposition and says, "Before I answer that question, I would like it noted on the record that this room is uncomfortably hot, the sun is shining directly in my eyes, and I have not been provided with water. I am requesting a break until the temperature is adjusted and water is provided."
Boom. Now it's in the transcript forever. Why is that so important?
Because if Galen's testimony later seems agitated, confused, or contradictory, the opposing counsel will try to argue to the judge that Galen is an incompetent expert.
But Galen's attorney can push back.
Yes. His attorney can point to the transcript and argue that the opposing counsel intentionally subjected the witness to physically adverse conditions, which could lead to sanctions against the lawyer or the deposition being thrown out entirely. You must document the environment.
It is wild to think that as an MIS student studying database architecture, your biggest challenge in a legal case might not be decrypting a hidden partition, but surviving a sweltering room.
It really highlights why the tech alone isn't enough. The tech is just the vehicle. Your physical and mental resilience is the engine.
And speaking of the vehicle, the literal tools a digital forensics expert uses can also be a massive ethical landmine. We've talked about human traps, so let's talk about software traps.
This is a huge area of vulnerability.
Because the tools you use to recover, hash, and track evidence, they are subject to intense, microscopic review. It's not like fixing your grandma's computer where you can just download whatever freeware works on Reddit.
No, absolutely not. This is where technically brilliant people often destroy their careers. They treat forensic investigations like a weekend hobbyist coding project.
Which you can't do.
Right. In a legal setting, your tools must be unimpeachable.
The sources bring up the dangers of using untested tools. Let's look at Patty. Patty is a brilliant coder. He realizes the commercial forensic tools are just too slow.
So he decides to build his own.
Yeah, he creates his own proprietary, custom-built software for data carving. It is faster, it is more efficient, and it's better than anything on the market. But his supervising attorney completely forbids him from using it on a live case.
And the attorney is completely right to do so.
But why? If it's objectively a better piece of code, shouldn't he use it to find the truth?
Because in the eyes of the law, a tool's brilliance is irrelevant if its reliability cannot be independently verified. Patty's custom software is untested and unvalidated by the broader scientific community.
It's a black box.
Exactly. If Patty uses his homebrew tool to find the smoking gun, the opposing counsel will immediately demand to see the validation studies. They will want to see the error rates. They will want to see the peer-reviewed papers analyzing how the tool's algorithm handles false positives.
And Patty won't have any of that because he just wrote it in his basement last month.
Exactly. And this triggers the Federal Rules of Evidence, specifically FRE 702 and 703, which govern the admissibility of expert testimony.
Oh, this goes back to Daubert.
Yes, these rules dictate that an expert's testimony must be the product of reliable principles and methods. The judge, acting as that Daubert gatekeeper we discussed, will look at Patty's untested tool and say, I have no proof this software isn't just hallucinating data.
So the judge just throws the evidence in the trash.
The judge will either completely disqualify the evidence, barring it from the trial, or issue a limiting instruction to the jury.
Which basically means what?
Basically telling them you can listen to what this expert says, but treat his magical software with extreme suspicion. Either way, Patty has failed his client and his profession.
Let me give you an analogy to drive this home. It's like a police officer showing up to a shootout, but instead of using his standard issue, registered, legally procured firearm, he pulls out a modified, unregistered, stolen gun he bought out of a trunk.
That is a stark, severe analogy, but
Even if that stolen gun shoots straighter and saves the day, bringing you to the fight completely invalidates his legal authority and makes everything that happens next fruit of the poisonous tree.
it is highly accurate in terms of how the court views unauthorized tools. And your use of the word stolen perfectly segues into another massive trap, which is intellectual property theft in forensics.
Let's examine the case of Nicole.
Yes, Nicole's case is a disaster.
Because Nicole didn't just build a new tool from scratch. She borrowed several libraries of underlying code from an expensive commercial forensics tool and baked them into her own custom software.
Without any attribution and without paying royalties.
She basically pirated the engine and put her own chassis on it.
Yes. And during the discovery phase of a massive corporate lawsuit, the opposing counsel, suspecting her tool is flawed, requests a protective order to review her source code under a non-disclosure agreement.
Oh no. So the opposing lawyers hire their own code auditors to look under Nicole's hood.
They do. And when those auditors find the stolen, copyrighted code, the forensic investigation instantly halts and a legal nuclear bomb goes off.
I can imagine.
It is no longer just a question of whether her data is reliable. It is a copyright disaster. Nicole is now facing severe civil lawsuits for intellectual property theft and potentially even criminal liability.
Her career's done.
Her professional reputation is permanently destroyed. The retaining attorney who hired her is publicly humiliated, and the client's original case is completely overshadowed by their expert's crimes.
It's game over. And it doesn't even have to be as malicious as stealing source code. Just being cheap with your software licenses can ruin you.
So true.
We have the scenario of Jolie. She's an examiner who needs to use a very specific high-end program called X-Ways Forensics to analyze a particular file system. But X-Way's licenses are expensive, and she doesn't earn one.
Right, so she takes a shortcut,
Yeah, she borrows a colleague's dongle and license key to run the analysis.
which is a direct, flagrant violation of the software's end-user license agreement, the EULA.
But who actually cares about a EOA? I mean, people click agree on those blindly every single day. Does a judge really care if she shared an account password?
A judge cares immensely when it involves the lawful collection of evidence. If the opposing counsel does their homework, and they always do, they will demand verification that Jolie is using software officially licensed to her or her organization.
And she won't have it.
When she cannot produce that documentation, she is exposed as violating a contract to conduct her investigation.
So the logic being, if she is willing to cheat a software company out of a license fee, why wouldn't she be willing to cheat on the data analysis?
Precisely. Her integrity is fatally compromised. The court operates on the principle that you cannot use misappropriated, unauthorized, or technically illegal means to gather lawful evidence.
So they throw it out.
The judge may disqualify her findings entirely simply because she was too cheap to buy the software.
The traps are just everywhere. Even if your software is fully licensed and you didn't steal the code, you can still fall victim to tool bias.
Tool bias is a subtle but major ethical failure.
The sources mention an examiner named Ethan. Ethan is a wizard at data recovery, but he is completely married to one specific preferred software suite. He knows every shortcut, he loves the interface, so he uses it exclusively for every single case, refusing to touch anything else.
By doing that, Ethan is committing a massive ethical failure of methodology. By demonstrating an absolute bias toward one single tool, he is violating the core tenets of forensic best practices.
But why? If the tool works, why does he need to use others?
Because every software program is essentially a black box of proprietary algorithms. Tool A might parse a corrupt Scully-Late database perfectly, while Tool B misses half the tables.
Okay, that makes sense.
But Tool B might recover deleted internet history from a specific browser much better than Tool A. Best practices dictate that an examiner must use multiple methods and multiple distinct tools to cross-verify their findings.
Oh, to check their work.
Right. If Ethan only uses one tool, he has no way of knowing what that specific algorithm is failing to see. He is letting a single software company dictate the boundaries of his investigation rather than his own scientific rigor.
So to avoid all these catastrophic traps, from opinion shopping to conflicts of interest to bad tools and software piracy, an expert needs an impenetrable shield before they ever start working on a case.
They need a strict protocol.
And that brings us to the most vital piece of paperwork in the industry, the intake form.
Yes, the intake form. For any digital forensics examiner or IT consultant working in the private sector, the intake form is not just administrative paperwork.
It's not just a bill.
No, it is your absolute first line of defense. It is your armor.
I think a lot of business students might assume an intake form is just a billing document. Like, put the client's name here, the hourly rate here, and sign at the bottom so I can send an invoice.
That's a common misconception.
But the sources make it explicitly clear that it is the most critical ethical document you possess. What are the mandatory sections of a proper intake form?
A comprehensive intake form must include detailed case information, highly specific examination instructions, meaning exactly what you are authorized to look for and what you are not authorized to look for.
Okay, boundaries.
Right. It also needs a complete inventory of the digital evidence being handed over, and crucially, an exhaustive list of the opposing party's information.
Why is the opposing party information the most critical part of that document?
Because, as we discussed with the disqualification traps earlier, the primary function of the intake form is identifying fatal conflicts of interest before you are ever exposed to confidential information.
Ah, to stop the taint.
Exactly. If you receive a call inquiring about your services, your strict rule must be that preliminary conversations can only involve hypotheticals.
Like, I have a client who may have experienced a data breach involving SQL databases. Keep it vague.
Exactly. No specific names, no corporate entities, no specific dates or locations until you are officially retained and the intake form is signed.
Let's look at the example of Ashton and Farouk.
They're a great example of doing it right.
They are ambitious entrepreneurs setting up their own private sector forensics consulting business. And the very first thing they design is a rigorous intake form process.
Yes. They use it to lock down exactly what hardware requirements are needed, what the timeline is, and most importantly, they run the opposing party's name against their internal database.
To ensure they aren't accidentally agreeing to testify against a former client.
Which would be a massive ethical breach. It is Business Protection 101.
But the intake form serves another much deeper purpose, right? It touches on the incredibly heavy human side of ethics.
It does. It helps manage personal bias and emotional limitations.
It forces the examiner to look at exactly what the case entails in black and white and ask themselves a very dark question. Can I psychologically handle this?
And that is a question you have to ask honestly.
That raises a huge, uncomfortable question that isn't talked about enough in tech. We assume data is just data. But what if I take a case, I sign the intake forms, I take possession of the hard drives, and halfway through the decryption process, I realize the evidence involves something completely abhorrent to my personal morals.
It happens.
Or something deeply triggering because of my own life experiences. Can I just put my hands up and walk away? Let's talk about the case of Isidore, because this is where the rubber meets the road.
Isidore's case is heavy, but it is an absolute necessity to discuss for anyone entering this field.
So Isidore is a highly skilled data carving expert.
Yes. And he is hired by a local district attorney to recover deleted files for a case involving the distribution of child pornography.
Which, horrific.
From the very beginning, Isidore completely despises the suspect. He finds the nature of the crime so visceral and sickening that he realizes maintaining complete clinical impartiality is going to be incredibly difficult for him.
He is human.
Yeah.
You can't just turn off your soul when you look at a screen. So can he go to the DA and say, look, I'm out, my bias is too strong, I can't analyze this fairly?
The painful structural truth of this profession is that the time to back out is before taking the job.
Before you sign.
Yes, that is exactly what the intake form process is designed for, to force you to evaluate your own emotional limits before you commit. Once you sign that form, once you are retained and you begin the analysis, you are legally and ethically bound by the Daubert standard.
Which means he has to be the impartial educator, even for a monster.
Yes, he must provide a complete, scientifically accurate, and entirely unbiased picture of the digital evidence.
But what if he finds something that helps the suspect?
If Isidore finds exculpatory evidence, say, a piece of malware that suggests the illicit files were downloaded by an automated script without the user's knowledge, and he ignores it or fails to report it simply because he finds the suspect disgusting and wants him to go to jail, Isidore is violating his ethical duty as an expert.
Wow.
He is committing a crime against the justice system. Daubert demands complete, sterile impartiality, regardless of personal disgust or moral outrage.
That is an immense, crushing psychological burden. You have to literally partition your own brain. You have to shut off your own emotional revulsion to ensure the data is analyzed fairly, because if you don't, the entire justice system breaks down.
It leads to severe secondary traumatic stress in this industry, and dealing with these incredibly heavy burdens, both the legal traps and the psychological toll, requires community.
You can't do it alone.
You cannot survive in an ethical vacuum. You need standardized guidance, which brings us to the organizations that write the rulebooks.
Because there is no single monolithic definitive code of ethics for all expert witnesses globally. If you are an IT auditor or a forensics examiner, you have to draw on standards from various professional organizations to stitch together your own ethical backbone.
Exactly.
The sources list quite an alphabet soup of organizations. Let's dissect the different flavors of these groups, because they all approach ethics from slightly different angles. Let's start with the ISFCE, the International Society of Forensic Computer Examiners. What is their vibe?
The ISFCD is highly rigorous. They focus heavily on strict objectivity and the use of scientifically validated principles. But their defining characteristic, the thing that sets them apart, is how they maintain the integrity of their organization.
Which is how?
Members of the ISFCE are explicitly expected by their code of conduct to report other members who violate the rules.
Okay, wait, let's really look at this. The ISFCE makes you snitch on your own colleagues.
Essentially, yes.
If you are a young MIS student, you are taught that networking is everything. Your reputation in the industry is everything. Isn't turning in your peers incredibly toxic for your career? Why would anyone join an organization that requires them to act as internal affairs against their friends?
I know it sounds harsh, but it exists for a deeply pragmatic reason. Protecting the profession's overall credibility overrides individual professional courtesy.
How so?
Think about the network effect of trust. If the public, the judges, and the juries begin to believe that digital forensics examiners operate like a cartel, covering up for each other's mistakes, hiding each other's ethical lapses, the entire profession loses its authority.
Oh, I see.
The Daubert standard collapses because the experts are no longer trusted as impartial. Let's look at the case of Fabian.
Okay, who is Fabian?
Fabian is a consultant who wants to get an ethical certification to put on his website to attract clients, but he absolutely refuses to report his friends if they cut corners or violate a code. He values loyalty to his buddies over the rules.
So what is Fabian's move here?
Fabian's move is to avoid joining the ISFCE entirely. If he cannot internalize that specific, difficult rule, the duty to police his own industry, he cannot honestly hold their certification. He would be a fraud from day one. He needs to look elsewhere.
What about the HTCIA, the International High Technology Crime Investigation Association? What is their core philosophy?
The HTCIA's core values focus heavily on the ultimate human consequence of the data. Their code places a massive emphasis on uncovering the absolute truth so that no one is wrongfully convicted. It is a very justice-oriented, consequence-driven code of ethics.
Then there's the IACIS, the International Association of Computer Investigative Specialists.
IACIS provides a very practical operational guide. Their primary focus is on the chain of custody and the integrity of the digital evidence itself. Their golden rule is do not alter the original data under any circumstances and strictly adhere to legal standards of search and seizure.
And the sources don't just list tech organizations. They mention the ABA, the American Bar Association, and the APA, the American Psychological Association. Why does an IT or business student need to care about the rulebooks for lawyers and psychologists?
Because the legal system is an ecosystem, and those organizations define how the courts view you.
Oh, okay.
The APA, for example, has highly enforceable, strict rules for psychologists acting as expert witnesses. It demonstrates to the court that scientific disciplines have rigorous, punishing standards for bad actors.
And what about the lawyers' rules?
The ABA is the most critical for us to understand. As we touched on earlier, the ABA model rules are the blueprint for state laws regarding lawyers. And those rules state unequivocally that experts, unlike the lawyers who hire them, do not have a duty of loyalty to the client.
Knowing that gives you power.
Understanding the ABA rules helps you understand the boundaries of the attorney trying to manipulate you.
It all comes down to internalizing that moral compass. So you aren't just following rules because you are scared of getting caught, but because it is who you are. We have the fantastic case study of Haven.
Haven is a great example of that internal compass.
Yeah, Haven works for a consulting firm, and her boss believes she is going to be an absolutely stellar expert witness. Why? Because Haven has a background in the Scouts, which instilled a deep moral code in her from a young age. And she belongs to a professional organization with a strict code of ethics.
She lives it.
Exactly. Her boss trusts her implicitly because her rules aren't just external traffic laws, she has internalized them.
When your internal ethics perfectly align with external rules of conduct, you become an unshakable witness. You don't have to remember what lies you told, because you simply follow the truth of the data.
But part of maintaining that unshakable standard involves opening yourself up to brutal criticism. You have to constantly test your own work and let others tear it apart. Which leads us to the final and perhaps most crucial step of the entire digital forensics process.
Peer reviews.
Peer reviews. A peer review in this industry is not just running a spell check on your final report, right?
No, not at all. The primary purpose is to rigorously confirm, validate, or scientifically dispute the findings and provide highly constructive, critical feedback. It is the scientific method explicitly applied to legal evidence.
The sources outline several different architectures for how a review is conducted. It's not just handing a paper to your buddy. Dive into the different types for us.
The structure of the review dictates its objectivity. You have an open review, which is the most casual. The creator might post an anonymized scenario on a secure industry forum, asking peers for feedback on their methodology.
Okay, that's pretty standard.
Then you move into blind reviews, which are specifically designed to eliminate human bias. In a single blind review, the reviewer knows the identity of the creator, but the creator does not know who is reviewing their work.
Okay, so the reviewer can be brutally honest without fear of retaliation.
Exactly. Then you have the double-blind review, where the creator and the reviewer are completely unknown to each other.
And the gold standard.
The gold standard for objectivity is the triple-blind review, where the creator, the reviewer, and the editor, coordinating the process, are all entirely anonymous to each other.
That sounds like an incredible amount of logistical overhead. Why go to all that trouble to hide identities? I keep thinking of it like a double-blind medical study for a new drug.
That is a perfect parallel.
You are trying to remove the placebo effect, but in this case, the placebo is the examiner's reputation.
Exactly. The forensic community is relatively small. If you are tasked with reviewing the work of a famous forensics rock star, someone who wrote the textbook, someone who speaks at every convention, Human nature dictates you might go easy on them.
You just assume they're right.
You might assume their work is flawless and overlook a critical error. If you review the work anonymously, you cannot be intimidated by their reputation. You judge only the data and the methodology.
Who is actually initiating these reviews? Is it just internal quality control?
It varies. If you are working in a lab, a colleague might ask you for a collaborative review just to bulletproof their work product before it goes to the prosecutor.
What about in private practice?
In the private sector, an attorney might hire you specifically to conduct a single or double-blind review. They might want a second opinion on their own expert's work before trial to ensure there are no weak spots.
Or they might use it offensively.
Right. More aggressively, they might hire you to review and attack the report generated by the opposing counsel's expert.
And when you write this review, it isn't just a summary email saying, looks good to me, or I think they messed up. The sources state you must include counterpoint arguments for every single point listed in a case report. That sounds absolutely exhaustive.
It is grueling, but it has to be. You cannot just offer a vague disagreement. You must provide technical evidence that either mathematically supports or scientifically disputes the other examiner's findings on a strict point-by-point basis. You are creating a roadmap of truth for the court.
Let me throw a massive wrench into this process. What if I am an independent consultant and I am hired by an attorney to review someone else's work, but I have a massive, deeply personal connection to the subject matter of the lawsuit? We have the case study of Hawkins.
Hawkins is a perfect example of navigating this.
Hawkins is a highly respected digital forensics expert. He is tasked with conducting a peer review of a forensic report generated by a major tobacco company in a liability lawsuit. But Hawkins has a secret. His own father died a painful death from lung cancer caused by smoking.
That is a profound conflict of interest based on personal trauma.
Right. So does Hawkins have to immediately recuse himself? Does he have to hand the case back and walk away?
This is where the ethical nuance of peer review is fascinating, because Hawkins is conducting a peer review behind the scenes and not providing direct testimony before a jury where his emotional state could prejudice them. He does not necessarily have to withdraw.
Really? He can stay on the case?
He can, however. He is bound by a strict ethical mandate. He must explicitly identify and document his personal bias in his report.
He has to tell them?
Yes. He has to formally notify the retaining attorney in writing that his father died from smoking and that he harbors deep resentment toward the tobacco industry.
He puts his bias entirely out in the open. He shines a spotlight on his own potential flaw.
Exactly. Transparency is the ultimate ethical safeguard here. By disclosing it fully, Hawkins transfers the risk assessment to the hiring attorney.
That's a huge shift in responsibility.
It allows the lawyer to decide if Hawkins' stellar, unmatched technical reputation in digital forensics outweighs the risk that the opposing counsel might discover the bias and use it to attack the peer review. Hawkins doesn't hide, he communicates.
It all circles back to that central theme, having absolutely nothing to hide. From the very first intake form you sign, establishing your boundaries and checking for conflicts, to the software licenses you meticulously maintain, to the final exhaustive peer review you submit. The digital forensics examiner's true product isn't actually the recovered data.
It really isn't.
The data is just the raw material. The actual product you are selling to the court is unshakable, bulletproof trust.
That is the perfect distillation of Chapter 15 and everything we've discussed today. The court does not inherently trust the data because the court does not understand the data. They must trust you.
And if they don't trust you?
If the judge or the jury cannot trust your ethics, they cannot trust a single bite of evidence you present.
So as we cross the finish line of this deep dive, I want to clearly recap the core practical takeaways for the business and tech students listening. You know, the future leaders who are going to be building companies, auditing systems, and testifying in court.
The takeaways here are vital.
First, protect your credibility with ironclad intake forms. Use them to spot conflicts of interest before they infect your career. Second, never ever use unlicensed, pirated, or untested tools. You aren't just being frugal, you're risking copyright theft, civil liability, and the total disqualification of your evidence. Third, understand deeply and profoundly that you serve the truth, not the client writing the check. You are an impartial educator. And finally, expect opposing counsel to test your psychological limits. Expect the sweltering conference rooms and the aggressive financial probing. Rely on your retaining attorney to protect you, but know your own limits.
If you can internalize those lessons, you will not just survive in the legal and technical consulting field, you will become an indispensable asset. You will excel.
Let's tie this all back to the dramatic scenario we opened with. The expert whose evidence gets thrown out, the one who causes the multi-million-dollar corporate case to collapse while the news vans watch. They weren't defeated by the data.
No, the data was sound.
The hash values matched. They were defeated by their own failure to maintain their ethical and professional armor. They got lazy with a software license or careless in a lobby conversation. Don't be that expert.
Protect the process, adhere to your internal compass, and the process will protect you.
Before we go, I want to enthusiastically encourage you to review our channel for other podcasts, playlists, videos, and classes to embrace lifelong continuous learning. Your education does not stop when you get your degree.
It's just the beginning.
If you found value in this series and want to expand your technical horizons, you absolutely need to check out the other relevant podcast series hosted right here on the channel. Specifically, the Ethical Hacking and Network Defense podcast series and the Network and Systems Security podcast series.
Both are fantastic resources.
They are incredible, deep dive resources for building out your technical toolkit and preparing you for the realities of the IT landscape. And remember, check the description for even more valuable resources we've linked for you.
To leave you with a final provocative thought to mull over as you continue your studies, building on what we've discussed today about tools, algorithms, and human bias.
Okay, let's hear it.
If we reach a point where an artificial intelligence eventually rates all of our forensic tools, autonomously conducts the complex data recovery, and generates the reports, who holds the ultimate ethical responsibility when a hidden bias deep in the neural network's code sends an innocent person to jail? Is it the original coder who built the AI? Is it the forensics examiner who blindly trusted the black box? Or is it the attorney who presented it to the court?
Oh, that is a chilling and incredibly relevant question that your generation of tech and business leaders is going to have to solve. That's a wrap on this episode of Digital Forensics. Until next time, analyze the copy, preserve the original.